All right. The Court of Appeal in the 46th District of the State of Florida is now in session. Honorable Danny Fraser, Chief Judge presiding. All persons having business before the call hearing. The God of the United States of America, the State of Florida, and the Honorable Court.
Thank you, Marshall Crawford, and good morning, everybody. Welcome to an oral argument session, 6th District Court of Appeal. This session is being streamed live on YouTube. If you have not already silenced your cell phone, we'd be really grateful if you did so. My name is Dan Traber. I'll be presiding today. I'm joined by my colleagues John Stargell and, for the first time, Roger Annam. We have two cases in the docket this morning. The first one is Rosemary Garland versus Progressive American Insurance Company. It's case number 23-399. Mr. Frontline. So before I start you, the default is going to be 5 minutes for rebuttal. I can increase or decrease that if you'd like.
No, Your Honor, 5 minutes is what I thank you.
The floor is yours.
May it please the court, Alex Frontline on behalf of Rosemary Arway. The issue before this court is what effect does the no action and exhaustion clause in this policy state that Progressive doesn't have to pay any UM benefits have on the statute of limitations for Ms. Arway's UM claim. And the effect is, as set forth in the unanimous decision of the Florida Supreme Court's decision of Woodall versus Travelers, is that the statute of limitations was told until Ms. Arway exhausted the tortfeasor's bodily injury limits of liability. And if we look at Progressive's policy in this case, and we compare it to the policy provisions that were at issue in Woodall, we will see that Progressive's policy is in all aspects materially similar to the Woodall language. First, the Progressive policy has a no action clause that states Ms. Arway cannot sue Progressive unless there is full compliance with all terms and provisions of the Progressive policy. The next provision is the exhaustion clause. Progressive's policy has this exhaustion clause, and it contains two important portions. First, just as in Woodall, it says Progressive only has to pay once. This is the second important part. Ms. Arway exhausts the tortfeasor's bodily injury limits of liability, whether by judgment or settlement. And what Woodall held is that the effect of those provisions had the effect of tolling the statute of limitations on a UM claim until the insured, here Ms. Arway, resolved and exhausted the tortfeasor's bodily injury liability. Now, what the trial court did was it distinguished Woodall and decided to follow the first district's decision in Bishop. And we believe that the trial court incorrectly relied on Bishop because Bishop doesn't have the same language as progressive policy. And to understand that, I think it's important to go to the Bishop decision and see how Bishop distinguished Woodall. So in Bishop, the first district said, look, the main material distinction in our policy from Woodall was that the state farm policy in Bishop contained the phrase legally entitled to collect. That was important for the Bishop court because the Bishop court found that phrase all through the meaning of exhaust into really an excess insurance clause provision rather than a true exhaustion clause as the court in Woodall interpreted it. And so, if putting aside the soundness of the Bishop decision for a second, accepting that distinction for purposes of what right now being a valid one, if we accept that distinction, the analysis should then really hinge on does progressive's policy, as in Bishop, contain the phrase legally entitled to collect, or does it not? Because if progressive's policy does not contain that phrase legally entitled to collect, then the meaning or interpretation of the word exhaust given by Bishop does not mean in excess of the tortfeasor's limits. Rather, it truly means what the common meaning of the word exhaust means, which is the tortfeasor's bodily injury limits have to be gone. They must be depleted before Progressive has that obligation to pay the UM benefits. And Progressive's policy does not contain that phrase legally entitled to collect. So the distinction drawn by Bishop from Woodall does not exist. We have the same phrase that the Woodall policy has, legally entitled to recover. We also have the same provision that says that Progressive only has to make payment once the limits of the feeser's policy have been exhausted. And then we have that prohibition on suit. And it's a prohibition on the filing of a lawsuit until that exhaustion has occurred. And so, again, circling back to the distinction made by the trial court and relying on Bishop, that distinction does not hold water here.
Counsel, let me ask, a lot has been made in both briefs about how the RWA policy is more or less like the language in Woodall or more or less like the language in Bishop. But focusing on just RWA policy and the Woodall policy, there are some differences. For example, in the exhaustion provision of Woodall, it refers to the BI benefits being used up. In the RWA, it says the benefits have to be exhausted by payments, judgments, or statements or settlements. I'm going to focus on that difference. Does the difference in language in the RWA policy make you more or less like what was going on in Woodall?
We don't think there is any sort of material distinction based on the phrase used up and exhausted. Those two phrases are synonymous.
What about judgments and settlements?
It still has to be exhausted first, and that's the key provision here, is that whether
it has to be exhausted by their case.
Well, which would have no effect then on the statute of limitations being pulled. If we have a higher bar than that in Woodall, then the tolling effect would be equally applicable in our case.
Do you agree that the Woodall court effectively made a policy decision?
No, I do not. I think we made a decision based purely on the policy language in that case.
It's interesting because I look at it, I looked at the UM statute, they basically said, all right, this is just procedural, right?
Well, for the first part in affirming Kelker, correct. And then
so they said, hey, this is just a procedural statute. And it almost struck me that as a matter of policy, they decided, all right, because this is a procedural statute. And I can't remember, I think it was an absurdity, a misuse of the absurdity factor, saying we're not going to use an absurd result. So it seemed to me that they made a policy decision and basically said, all right, so it's going to be.
Well, it reached that decision based on the policy language in that case. The whole thing is stated twice.
And I'm not saying I'm not suggesting that the Florida Supreme Court can't make a policy decision as it relates to contracts. If it says that the statute doesn't apply, then can it just say, all right, even if it's invented tolling mechanism?
Well, the tolling provision was based on the contract language. I mean, that's the court said in two portions of the opinion. We're basing our holding on the language and the policy, not on some public policy consideration. This was something rooted in the insurance policy as opposed to public policy. But it is something tethered to the language in the policy.
So are you saying that it would be a fair reading of Woodall that the parties essentially contractually extended the statute of limitations beyond 5 years in the event that there has not been exhaustion of benefits yet?
Yes, Your Honor. That's what I think is a fair reading of Woodall to say. And that language and that thing has existed in our courts since 1997. And since then, you know, Progressive wanted to get around that contractual tolling language in Woodall as a very easy fix. As an insurance company, it is the master of its insurance policy language to alter that language. But instead, it inserted into this UM portion of the policy language that is, in all material aspects, the same as that in Woodall.
I think the legislature has spoken in the last 6 years too.
Absolutely. That legislative acquiescence shows that the legislature does not have any problem with the Woodall decision, particularly since I think Your Honor's alluding to perhaps the tolling statute that was referenced in the briefing.
Or an amendment to the statute or some other amendment to Chapter 95.
I mean, all these provisions pre-existed Woodall. They've existed since Woodall. And the legislature has altered, whether it's the UM statute or 9505 to address that legislative inaction is the tacit approval of the Florida Supreme Court decision, because if it didn't like that decision, it could have, after its prerogative to the statutory scheme to either change that rule that was set forth. That has not happened. And so we just revert then what was the language in this policy, as Your Honor noted, that the parties contractually agreed to. And the effect of that language under Woodall is that the statute of limitations was told until Ms. Harlan exhausted the tortfeasor's bodily injury limits. That means the trial court, which held there was no tolling at all and granted the statute of limitations without any consideration of tolling, we submit improperly amended the summary judgment motion, and we would ask this court to reverse and remand for further proceedings consistent with the statute of limitations being told under Woodall. And unless this court has any questions, I only have more than 5 minutes left.
Counsel, I want to ask you about the tipsy coachman issue that was brought up in this case. I believe it was your briefing that cited the Sousa case from the 3rd DCA, essentially saying it's well settled that the tipsy coachman doctrine does not apply in our review of the summary judgment. I don't know what the 3rd DCA means by well settled. They didn't exactly cite to the long history of cases or anything from the Florida Supreme Court. Should our court adopt that same rule? I mean, what is the principle behind saying tipsy coachman apply at the motion to dismiss stage, apply post-trial, but it doesn't apply at the summary judgment?
Certainly. So yes, we do think this court should follow that. And it wasn't just the 3rd District in Sousa. Prior to this court being created, it was a rule that every district court had followed in the state of Florida. And I think the rationale for that is twofold, or has several different points. First, when we look at the rule of civil procedure governing how summary judgments are to operate, one of the requirements is that the summary judgment motion must state with particularity the basis for the motion being presented to the court. If the motion doesn't contain those grounds and it's not presented to the trial court, then there's no appropriate basis for the trial court to rule on something in violation of the summary judgment rule. That's part of the rationale that SUSA in those cases go to, which is to say, we can't go and affirm a grant of a summary judgment motion on something that was never even presented in the first instance.
What if the summary judgment record created by the parties would support a purely legal ruling? In other words, not a ruling that the non-movement could have addressed or put more in the record to avoid it, but purely a question of law that is supported by the summary judgment record. Even then, would it be proper, you think, to affirm on that alternate basis?
I do, and that takes me to the second part of my summary judgment rule component. Subpart A of our new rule says that the trial court has to state the reasons why it is or is not granting a first judgment. And like Judge Bilberry said in the 16th Town Council case, to affirm a grant of summary judgment based on a reason that the trial court did not rule would effectively eviscerate that requirement and allow this court to rule on issues for the first instance on appeal.
What is the Florida Supreme Court's directive as of May of 2021 that we have wholesale adopted the federal summary judgment standard, even going as far as adopting the verbatim the rule? I haven't searched the whole country, but I certainly found dozens of 11th Circuit Court of Appeals cases that apply what we call the Tipsy-Coachman doctrine in review of summary judgment. Should our adoption of the summary judgment standard extend to the district court's review of summary judgment? In other words, should we be following what the federal courts do there, or is that adoption of the federal standard limited to trial court proceedings?
Well, I think it should be, the rule is limited to the trial court proceeding in the adoption of Rule 1.1. But what I think we've seen is in considering how that rule operates, and this is the new rule, the requirements set forth in it, the particularity requirements, the requirement for the specificity in the order. Those components of the rule have been considered as a basis for our courts to say, look, we're not going to affirm a Tipsy-Coachman grounds a summary judgment rule when those bases were not actually presented to trial court. And I would step back and say, as a matter of perhaps judicial restraint, not saying that anyone here is cavalier or anything, but I harken back to the Frederick versus Dolgan case that we cited in the briefing, and I was the appellate counsel on that. And I recall Judge Silverman saying, at the oral argument, it would be more prudent to allow the trial court and the litigants to develop these issues and bring back to the court a fully developed record rather than addressing this in a true manner for the first time on appeal. So again, we think Tipsy-Coachman would not be an appropriate basis for the reasons stated in the brief and we discussed here today. Woodall controls, there is a tolling agreement or tolling of statute of limitations here. As I stated, we'd ask this court to reverse. Thank you.
Good morning. Kansas Gooden on behalf of Progressive. This court should affirm the judgment in favor of Progressive, and starting off this case is not Woodall. Your Honor made a really good point about the legislator could have done something. Well, they did. So if you actually look at the basis within Woodall and the Section 6 quote within the UM statute, it contained very important language. And it basically says that if the carrier does not waive subrogation, then it may then file suit against both the tortfeasor and the carrier. And that liability limits was then be exhausted. And that language was removed in 1992. So our current statute, which is part and parcel of any insurance policy in Florida, does not contain that language. So I do think that the legislature did speak with regard to this. Now, even though Woodall was a 1997 case, it was operating under the prior statute because this was a 1987 accident. And it's always the statute that occurs at the time that the accident applies. So that language has been removed. So that's my first point. So this case is different with Woodall, not only the statute that's different, but also the policy. The exhaust versus used up is different, and there's been much to do about the term legally entitled to recovery and the use of that within progressive policy. That is straight from the statute. It's the very first sentence of the statute. It basically describes when somebody can make a claim. And so basically every insurance policy within Florida mirrors that language right now. So I think that really should kind of guide this court that language is within the statute.
Let's talk about the exhaustion provision specifically.
Okay.
Just about civil complaint that's filed includes the allegation, all conditions present have heard, have been satisfied. Under the language of the RWA policy, is we will pay only after the liability has been exhausted for payments of judgments or settlements. What's the earliest point in time that this RWA could have truthfully alleged that all conditions precedent have been satisfied?
Well, that is not, in our opinion, a condition precedent under this policy, and here's why. So this language, when you read it with the limit of liability provision, which we cite in our policy, it talks about when kind of payment can be made. And if you read all of that together, it basically mirrors Section 6 of the statute. It talks about, in Section 1, for that matter, that basically the policy is over and above any liability policy. And that makes it just an excess policy. And so they could have made a claim from day one, right after the accident. They could have sent a demand for But what ends up happening is, under any policy, it doesn't necessarily kick in until, say, there's PIP, there's the liability policy. So in this case, I believe the liability policy is $50,000, PIP is $60,000. Mrs. Harway's damages would have been in excess of $60,000. That would have triggered a claim from day one.
Well, suppose Ms. Harway just catastrophic to where no reason to argue that her injuries would not exceed the limits of high coverage. You're saying that she could have sued immediately under the UN partner policy without waiting for the exhaustion of the benefits.
Absolutely. She could have, the day after the accident, she could have filed suit. The day of the accident, she could have filed suit against Progressive.
And what if the BI carrier wouldn't settle and required her to litigate against them? And it takes 4 years under, the 5 years, that she's filed suit, and it's 4 years, 364 days later. What keeps the statute from running on the UN benefits? Or let me ask you this way. When would the UN carrier, when would Progressive be required to pay, or would it be required to pay prior to resolution of the BI liability of the tort user, which would then trigger the BI?
Anytime damages in this ROA exceeded the liability limits and the PIP limits. So basically, if you read in Section 1 of the statute, it kind of sets forth all of the insurance coverages UM is over and above. For instance, personal injury, protection, the liability, insurance. Once it gets over and above those, there's a trigger to pay policy. And so again, if that happened day one, they could have filed suit day one. And this is why most lawsuits, when there's a claim, they fall against both the tortfeasor and the carrier at the same time.
Thanks, the hypothetical. Assume a non-catastrophic accident, assume, for example, an injury that's serious enough to maybe require surgery, but you've got somebody who's basically trying to fight it. Further assume a reasonably priced BI policy that's going to be done. Could you have a situation in that instance where a plaintiff might not know in good faith that they could advance a BI claim until they realize the full extent of their damages? In other words, what about a situation where maybe I'm injured $100,000, maybe I'm injured $500,000, depending on surgery and quality of life. How could you say that at that particular point, I in good faith could sue the UM claim?
I think because a plaintiff attorney would,
Not just in the realities of the economic system, let's just assume uniform under the UM statute, under the policy language. How in that particular situation could you know whether you had a UM?
well,
And isn't that the point of Woodall?
Well, I think Woodall, I think Your Honor described earlier, it was a policy decision that misapplied the absurdity doctrine. But if you look at Woodall, everything that happened in that case happened well after the statute of limitations had been. And so I think when you enter into a contract, even an insurance contract, you are assumed to know the contents thereof. You are assumed to have read it. So I think that puts any party, any party to the contract on notice as what those terms are. And so to say they didn't know they could have done it, I think
No, my hypothetical is they don't necessarily have a good faith basis because the BI and UM claims are so potentially overlapping. So in that particular instance, what do? Do you sue and get the 57.5?
I do. I think you sue because
well, you'd have to sue, right? Because
you have to sue.
Because under your position, you malpractice because theoretically the statute has to run at 5 years.
Yes.
I'm having trouble reconciling that answer with Woodall's holding.
And I think, and this is why I think Woodall has been limited to just language, and that's why Bishop went the way it did. Because if not, so let's look at this hypothetical. Let's say this BI case was stayed because of a bankruptcy or somebody died. It stayed. It goes on for 15 or 20 years. I know we'll just all get that, but let's hypothetically say that. It goes on for that long. Could you then come back against a UM carrier 20 years later and then make a claim? There has to be some finality. And that's exactly what the statute of limitations does. It gives finality. And that's why the Bishop Court went the way it did, to give finality.
So counsel, let me ask it this way then. Is it your position that the UM statute, the statute of limitations, and the list of the list of things that extend the statute of limitations or that reflects a policy decision by the Court of Arbitration that 5 years is enough time to obtain your UM benefits, regardless of how difficult the third-party tortfeasor and the BI carrier might make things, either intentionally or just because litigation and settlements can take a long time. In other words, this is the policy decision that 5 years is enough.
Absolutely, 5 years is enough. It's a long time. And by that point, people have been treating actively after a car accident. It requires people to get treatment within 14 days. So they are treating, they're actively moving their case along. They will have known by 5 years. And in this case, they absolutely should have known, because if you even just look at the facts of this case, the accident occurred in August of 2015. In November 2018, within that 5-year statute, Norway sent a letter to Progressive asking for basically approval of the BI settlement and a waiver of subrogation. Progressive did that and then started offering money for UM. They made several offers and it went back and forth for several years, and they let the statute of limitations run. This is not a situation like Woodall. The UM carrier wasn't even contacted until years later. This is all happening. They could have got this done, and so we believe this case is definitely more akin to Bishop than it is to Woodall. And I think it's important too that, courts don't violate case law. If a case is distinguishable, it doesn't apply. If the facts are not substantially the same without any material difference, courts are not bound to follow it. So this court is not bound to follow Woodall.
Seems to me that the sister court with client and its peers in a bad spot in terms of saying that you can't require somebody to sue the union carrier. This is Saul's void against public policy. So you can't require them in the policy language to sue the union carrier. And then you've got Woodall that basically says, well, we're going to, because reasons, tolling. So I wondered if, following back on my colleague's question, your colleague, if the way to interpret policy language moving forward, then based on that bad spot that your client's industry has been put in by these particular cases on it. This isn't just agreed upon tolling. The insured that we're going to contractually agree to lengthen the statute of limitations.
Well, and I think if you read the insurance policy as a whole here, there is nothing that said you could not file a suit before you got the BI limits.
Let me follow up on that statement. The language from the policy says we may not be sued unless there is full compliance with all the terms of this policy. Are you saying that exhaustion of BI benefits on payments or judgments is not in terms of the policy that have to be complied with before you may be sued?
No, because if you actually look at the case law surrounding the no action clause, it has to do with duties under the policy. The duties under our policy are located on the record, I think it's 308 to 310, but these are kind of post-law duties. For instance, submitting to an EUO, submitting to a CME, sworn proof of loss, reporting the accident to the carrier. Those are all cases where that no action clause comes into play and has force to it.
Well, is there a difference then in Woodall, no action clause says unless the insured has taken control of the provisions of the policy, the ROA policy is written passively unless there is full compliance. It doesn't specify that the insured must comply. Does that make a difference?
I don't think it does. At the end of the day, I don't. Because again, you have to read the policy as a whole in all of its terms. And so those duties, post-law duties, are in the general provisions of this policy that get written into it. And so that is what compliance is. So I think just viewing that no action clause in the case law that has really developed since 1997 on the no action clause, that's how it's interpreted and that's how it is applied. I would like to switch a little on the tipsy coachman argument. This court, of course, has not dealt with in the context of the MSJ. And also the Florida Supreme Court has not dealt with it in the context of an MSJ and has not limited in that manner, but they have applied it in an MSJ. And that case is Excelsior Insurance Company versus Central Park, and this is a very old case from 1979 and with policy interpretation, just like this case. You know, my opposing counsel made a point basically saying, well, the rule requires the trial court to state the reasons in the order, and that's why tipsy coachman cannot be applied. But let's think about what other orders that the judge has to include specific reasons. Orders granting motions for new trial, motions for sanctions. All of those have to have reasoning from the trial judge. Guess what? Tipsy coachman applies. So what's the difference now between the current rule and those situations?
So one response might be that the summary judgment rule is different because it represents some trade-offs. The summary judgment movement wants to deprive the non-movement of trial. And one of the trade-offs that requires the summary judgment to engage in some precision in presenting the claims on which there is no genuine dispute fact. So is it possible to have a tipsy coachman rule that, or should the tipsy coachman rule that we adopt here allow recognition or consideration of an alternate ground, even if it was never raised at all by the summary judgment, as opposed to a situation where, suppose, in this case, those various defenses or alternate grounds raised in the brief were raised in the summary judgment motion. The trial court just simply ignored and decided the case exactly as it did today. In that case, at least the grounds were raised, you had an opportunity to respond, and then it would come to the court with just being capable that wasn't what the trial court relied on, but it's still there. Whereas here, it just wasn't there at all in the summary judgment paper. That's still appropriate for us to consider those issues.
I think so, because if you read Dade County, I can never remember the initial of the radio station, but if you read that case, it does not limit it to only what has been argued. It says if the reasons are supported by the record at all. And I think that's the difference.
Seems like they might have amended their pleadings. You know, it's not whereas if you're at a trial, you know, pleadings are closed. And I recognize that there's a little bit of buzz or lack of because it strikes me as a policy conflict, efficiency, reservation, and finality that I don't necessarily feel were the best to China.
The summary judgment rule is a trade-off, and it is supposed to be about efficiency and getting somebody finality. And so there are all of those things, but they absolutely could have amended their plea, and they probably should have. And I mean, the other thing that was dealing with, if you look at the record, they filed their response to the summary judgment less than 2 days before this hearing. And so it put Progressive in a bad spot. I mean, they're playing consecutive fiddle trying to catch up, moving to strike, objecting. And it probably should have been focusing on the hearing. There was no opportunity to file a reply whatsoever or anything of that nature. So
But it just seemed like your ideas as opposed to the trial counsel's ideas, which is part of it too. They were excellent. Like they had any notice below, whatnot, which if you can't tell by my reticence,
Yes.
for the one into a summary judgment. And feel free to just respond to that statement.
yeah, I mean, I definitely understand the reticent, and it is, again, it is a judicial restraint issue. It's giving, due process, and I completely understand it. But I do think if all these things are in the record, and I think if this case, there's a lot of cases that have been developed where if that response was late, the judge just doesn't consider it. And it's just based on the summary judgment motion too. So I think there was a lot happening at this trial level that made this, even though it's a small record, it's a little messy record at the same time. Do you have any more questions? Thank you. I ask this court to affirm. Welcome to the court.
Thank you.
Brockmeyer rebuttal.
Again, made for this is a contract case that's based on the contract language. If Progressive wanted to avoid the tolling effects of Woodall, all it had to do was change its contract language.
How could it do that in light of the public policy cases that it couldn't require filing a suit?
Well,
What's that contract?
I think what we have is you don't have the obligation of Progressive paying the limits contingent upon the bodily injury limits from the tortfeasor being exhausted. Because remember, the public policy consideration that we're concerned about is the prohibition on the UM suit being filed before the bodily injury limits were exhausted. So if we remove the obligation or the payment obligation and have that removed, it be contingent on the exhaustion, then this is fine. I mean, you simply just say the bodily limits of, the limit of bodily injury liability just need to be in excess of the limits available under this UM portion policy. That's just a true excess clause. That's what they're wanting to accomplish. That removes any prohibition on exhaustion. That removes us from all those cases like Ryer that get into this public policy dispute. But I do want to be clear with the court. Ryer and every other case that Progressive cites on page 20 of its brief all stem from Ryer. Woodall considered right when it rejected this argument that progressives trying to raise on appeal. And it said, look, we're going to look at what the contract says. And I've already discussed with the court why I believe Woodall and its policy language is material and on all fours with the policy language we have in this case.
What's your response to opposing counsel's that Judge Jeff addressed this? So it was prior to Woodall was really interpreted prior statutory constructs.
The change would have to be in light of Woodall's tolling argument with respect to this policy language, because Woodall is interpreting this policy language as it existed, as it was drafted. The legislature isn't altering the UM statute to address Woodall. So it's the legislative acquiescence to the interpretation given to Woodall, whether it's under the UM statute or tolling provisions. Real quick, Judge Traver, you had mentioned the certification argument and the reply issue. This issue of Woodall was squarely before the trial court from the motion to this stage. In fact, the trial court initially found that Woodall was applicable. So if, as you noted, this had been raised in the summary judgment motion and said tolling under Woodall is waived, you would have moved for leave to file a reply. But instead, what the summary judgment motion did, rather than urging waiver based on lack of a reply, was it simply addressed Woodall head on the merits and argued it was not applicable. We had no reason to think that there was ever going to be a waiver argument on this based on the lack of a reply, because it was always before the trial court. There was always something progressive new we were arguing. So, we used that rule of try by consent. This was argued by consent. It was always before the trial. It was always in front of progressive. So, again, we believe this case is controlled by Woodall. We would ask the court to affirm, because the policy language in progressive's policy is Woodall's policy language, and that effect is the limitations period. Thank you very much.
Thank you very much for your argument. It was well done on both sides. Be at recess until 10 o'clock.
Testing 1 2. Testing 1 2 3. Testing 1 2 3. Testing 1 2 3.
seated.
All right, we are back on the record. Welcome to those of you who are joining us. This is an oral argument session of the 6th District Court of Appeal being streamed live on YouTube, so please silence your cell phones if you have not done so already. My name is Dan Traver. I'm the presiding judge today. I'm joined by John Stargell and Roger Canham. The 10 o'clock case is C. Jeffrey Arnold et al. Versus Donald Bronson et al. It's case number 23-621. Mr. Frost. Sir, the default rebuttal time is set for 5 minutes. I can move that up or down if you'd like.
That is completely proper, Your Honor.
The floor is yours, sir.
Thank you. Good morning. My name is John, and I have the privilege of representing the plaintiffs, the appellants, Arnold's in this case. Sitting with me at counsel table is Jeff Arnold, who is co-counsel and also the plaintiff. As this court knows, there are certain facts that are undisputed in this case. First of all, the mineral rights date back to 1943, and the deed which sold certain of the property, which is now the Bronson property, but not the Bronson at that time, but reserved the mineral rights on the land. It is clear that Mr. Bronson does not own the mineral rights. If you look in the record at page 15-543, Mr. Bronson's depot, page 8, line 4 through 6, he says, and the question was, and do you own the mineral rights? Answer, no, sir, I don't own the mineral rights. There's no doubt that the mineral rights are not owned by Mr. Bronson, but are owned by my clients. Bronson has held and has been the land, the Bronson land, has been mined, and there is a contract for future mining on this land to mine what is on the land. There's no dispute about that. What has been mined and brought and is assigned or leased to be mined on the Bronson land is that is what's been mined. Donald Bronson has been paid over $2.2 million for the rights for the quartz mined and the rights to mine the quartz. No dispute about these facts. If you'll know, at the trial, we put on all the evidence we rested and Bronson put on there. The quartz on this land is very special. And the judge found that he found that if you look at his order, he found that 94 to 98% of the quartz that was being mined is mined on this land. 94 to 98% quartz. That's important because what that does is that gives the sand as a special value. And the case law says if it has a special economic value, then that is mineral that should be recognized. And we'll get into that case law. But the quartz that is mined on this land, and there's no dispute that that's what's being mined, does have a special value in that it is good to make concrete or cement. All quartz.
Let me ask you a little bit
Sure.
just about the parties' standing. There wasn't a lot in the record. I don't think there was anything in the brief about what those words, all gas, or all oils, gas, and minerals under said land would have meant to somebody. I guess as a preparatory matter, do you accept? It's been in a lot of court cases recently, the concept of supremacy of the text. That we give the words the effect of what they meant at the time that they were written.
Sure.
So in that particular instance, what is there in the record that allows us to know what the parties would have thought was being given in respect to 1940? What does it mean in that context?
Well, I think in that minerals in that context mean what minerals are. Minerals are what minerals are. And quartz is a mineral. Always been a mineral. There's been no doubt that quartz is a mineral. And if you look at the case, the Supreme Court case was decided, I think, decided way before, I think, 43D, or the discussion about the land that was involved in that case, dealt with land and dealt with sand, supposedly, that found that sand was a mineral.
That was a case that was dealing with the Stock Raising Act statute in 19, as opposed to
Right.
basically a contract between two private parties in Florida in 1943. Let me ask you this. So the way that it's phrased in the deed is oil, gas, and it's misspelled, minerals, undersea land.
Right.
What do we make of the notion, and there's the canon of interpretation, basically talks about knowing your canons. So we have oil, value, right? Gas, value, something that you can plug equipment on the land, put oil derricks, mine it. And then the third concept, minerals. We infer by the fact that oil and gas were absolutely valuable in 1943, especially in the World War. Can we infer that minerals would also have to be valuable at that time?
I think you can infer that minerals are valuable, and that you're looking at valuable minerals. There's
You
nothing
might
in
be, and this might be where we're passing each other a little bit, because it seemed like all the trial testimony was we can take 97% quartz sand out of this property in 2023 and sell it to CMEX, even though we weren't at that time in 2023, even though we're paying the lease. We can sell it to Highway Corporation because they don't want to carry things across lines. But in 1943, did sand have that value in Florida?
That's an issue. I think that I don't think anybody went back and looked, but I think that quartz in that time had a value, because you're making cement. You've been making cement forever.
Isn't the failure to look, though, problematic for your clients in the context that if we're going to look at, again, 1943, oil, gas, minerals, we don't have anything. We have experts that are basically saying it's valuable now, but we don't have anybody saying it had any value in 1943.
Well, but we don't have anybody saying it didn't have any value in 1943 either.
Don't you have the burden of proof?
Huh?
Don't you have the burden of proof below?
I think the burden would shift to them. If I showed that it's valuable at this time, they would have to say that it's not valuable in 1943. I mean, I have the burden. I come in and say, okay, here, I've got this sand on this property and it's valuable now. You're going to have to tell me it wasn't valuable back in 1943. I think that burden goes to them at that point. I think the assumption is that sand has been there, which the testimony was, it's been there all the time, that in 1943, and it was mined back years before this. We know it goes back before 2000. We know it goes back a little bit, so we don't know how long it's been. I think 57 or so when the first mining lease was in there. So it's going back a ways to show that there was value back then when they started mining it. And it was mined a long time before this time that we're here right now. That's in the record when it started to be mined, etc. And I think there's no dispute that this is a unique type of sand. Whether it's sand or not, whatever it is, it's a mineral quartz, but it is. You can't look at the sand without looking at what is that sand. You have to look at that. And that's why we think the cases that cited by the defendants in this, nobody analyzed the sand that was analyzed in this case. This case was analyzed and determined very high quality, very unique in that it was available to do concrete. And concrete's an important industrial item that makes this stuff very valuable. And it's got to be valuable in that, and when you talked about it hasn't been mined, but it has been converted, case out of the second district, or this was the sixth district, says that mineral rights are separate property rights which can be converted. That's what we're saying here. And Mr. Mott with FEMEX said if somebody else came in here and tried to mine this, we would object because we have those rights. And so I think it was converted, and these are mineral rights. I think if we go through the judge's order, what he did is he got it respectfully that what he did was he didn't apply the law he cited to the facts in this case. And if you look at it, what he found is he found how valuable it was in saying it was 94 to 98% quartz. And then he gets over there and he says, if we look at his opinion, he talks about the Florida Audubon Society, he cites to Hernandez versus Allen. And the language is important. It says, in our opinion, substances such as sand, gravel, and limestone, not minerals within the ordinary and natural meaning of the word, unless they are rare and exceptional in character, or possess a particular property, giving them special value. And then they use an example. This is from the case. As for example, sand is valuable for making glass, and limestone of such quality that it may be profitable to be manufactured into cement. Substitute the word sand for limestone. He's finding that in that case, this sand possesses a valuable criteria, a valuable item, because it can be made into cement. That's what the case law says.
Counsel, I want to look at the distinctions that you're drawing there between valuable sand or special sand. There's also a reference, I believe, in connection with that sand of such high quality. I believe there was a reference to it being pure quartz, pure white quartz that could be made in glass. And then with respect to limestone, it could be made in cement. Is there a presumption that sand can be made, but only special limestone could be made into cement, which might elevate it to that category of being so valuable that it would be deemed a mineral? Because all sand is made of minerals, gravel minerals. Limestone is a mineral. Yet the cases seem to make a distinction between these sort of superficial substances, lime, sand, and gravel, and under the surface, valuable materials like oil, gas, and minerals. You can take out the oil, gas, and minerals without the surface, but sand and limestone and gravel, you can just excavate it right off the surface, destroy the surface process. So,
well, I disagree in that all sand cannot be made into cement. All sand is not strong enough. It's the quality of the grains that make it into cement. It's got to be high quality. If everybody had sand that was going to be made into cement, everybody would be mining on their property. The mining of coal, for instance, you can't mine it off the top. It's a mineral that you take from the bottom of the soil. This that's been mined on the Bronson property has been mined by going and digging down underneath the soil to get the sand. And what's done is left a bunch of lakes there, so basically probably improved the property value. But that's how it's done. It's mined. It is a mining lease. It's not a lease to scrape it off the top of the soil. So,
how is the lot 33 and 34 sand different from other sand? In other words, what's the standard to put sand out of the regular non-mineral sand category into this special mineral sand category?
The amount of quartz that's in that sand.
What is that percentage?
There is a line drawn by the FDOT as to what is fine quality, fine aggregate. And this quartz on this property is 85% of C fine aggregate by the FDOT.
Is that FDOT standard what we should look to decide whether sand is of such high quality that we would deem that part of this oil, gas, and minerals category?
You can look to that standard, and that was what was looked at. Now I'll get to that. what was looked at is when it determined that this was high quality sand. The testimony by Mr. Hurt, who was the engineer that was hired by CMEX to look at all this sand on this property, has testified that this is very high quality sand that can be used for cement. He says it's the aggregate, the fact that it's 94 to 98% quartz, what makes the hardness that makes it so valuable to make cement. And so it also, the other testimony, it is so hard that they use it in sandblast. It will take the paint off of anything. So again, this is a very good commercial use. And therefore, that's what, if you look at the case law, that's what makes it such that it is a high quality, special value type of quote sand. You know, it's just like, what are you going to find when you just use the term sand? Sand is only the particle size. So if you have gold particles that were just labeled as sand, want to mine your sand, but they're particles, then that gold would not be, their argument would not be something that would be a mineral that could be worth anything.
It's 1950. They usually had a T standard side with a large tract of land. Had everybody knew about Florida, which is the same as a mineral. They weren't any other. We had to, what was the intent of the party? That's a trader's question. How did we? That's what brought whoever was involved back when they're president. That's what they meant. You could use that today. You know that and make various qualities. But this particular thing, does that make it what the party's intent when they?
I think when they intended any mineral that existed would exist in the future. Because I think it goes on to say any and all minerals.
Is there anything in the record that suggests that if Mr. Arnold or his predecessors tried to, in the words of the deed, explore, develop, or mine at any time before your lawsuit?
I don't know that there's anything in the record that says that. I don't know that there's any requirement.
It'd be good for you, right, though, that in 1944, a whole bunch of their predecessors showed up with shovels, said, we want to get the sand.
Yeah, maybe. But I mean, 1940.
What do we make of the absence of that sort of testimony?
Well, I think you make the absence is that I think that you're going to have to assume that when we said minerals, we want all the minerals that are there, whenever they're there, whenever they're determined to be minerals. How are you going to say that they intended the courts not to be?
Doesn't it, to Judge Stargell's point, I think, show
Why would that be? I don't follow you, Honor.
Because if in 1947, someone showed up, the original grantors with the reservation of the mineral rights showed up with a bunch of backhoes and said, here for your sand, because it's a mineral, and you have some argument as to what the original intent of the party is. If you're going to concede, and I think you have 1940 as value, that'd be a beautiful thing for you.
Well, maybe they aren't in the sand mining business then. I mean, you reserve mineral rights. I mean, it's clear here. So what
if it, huh? What if it, you know, in other words, I'm reserving these mineral rights for you to know there's a gold mine on the property. We can't conscientiously say that sand in 1940.
Well, I think you can say that they did. We're getting a distinction here between sand that is on the surface, that there is sand. This sand that is down and being mined further down than just a label of sand there's a distinction of the value and what minerals are.
Have you well into your rebuttal, sir? That's my fault.
Okay.
Do you want to reserve the last minute for your rebuttal?
No, I want to reserve the last minute.
Yes, sir. Counsel, you'll have to help me with your last name.
That's okay. Tondro. Just mix all the letters and there's all from my mistakes. May it please report opposing counsel. Good morning. My name is Maddie Hardin, and I have the privilege of representing Donald Bronson and the Donald Bronson Ranch. With me here today, I have Clint Bronson, Mr. Bronson's son, and their ranch hand. It's commonly referred to as Shorty. I'm going to blank on his first name, but we'll make a record of Shorty at least. Also at council table, I have Billy Ball, who's a partner at our firm. I think we can, I'm not an appellate attorney, I'm more of a trial attorney, so my probably be more targeted in broad sense. But I think that you have to look at this case from a broad stroke view as to what the underlying law is in the state of and I understand, especially from Friday's luncheon, that this court is not under some presidential value, so to speak, that everything is somewhat persuasive being a new district court of appeals, but also the fact that there is a scarcity of case law applicable to Florida case law, at least applicable to the situation that we find ourselves in here today. I think if the court takes a step back and looks at the general principles that have been delivered since the early 1900s, prior to 1943 and subsequent to 1943, then the court will realize that Judge Durden's lower court order was in fact consistent with the law across the United States. What's important in all of that is that when you sever an estate of land, you have the dominant owner and a servient owner. The dominant owner being the one that receives those mineral rights, and the servient owner that receives those surface rights. Case law is very clear, and what is really important in that severance is that one use should not exclude the use or impair the use of the other. And so when you go back and you look at whether it's limestone, gravel, and all of which have been considered by courts across the United States, the main difference between those local use compared to that of gold or a we call it locatable mineral would be the fact that when you go and you have a gold mine, you don't necessarily the surface of the estate. When you mine sand, mine limestone, when you mine gravel, you destroy the complete surface of the estate. What you'll find in the record is this person's testimony basically says when you're done mining sand in a particular area, the only thing you're left with is the background. The best need for that use, you've destroyed that surface and that effect. And so that's where I think in the broad strokes of things, these courts have looked and analyzed this issue of we cannot, if a deed were to convey the surface minerals, so to speak, it would in fact destroy the conveyance that was instantaneously made to the surface. It would be conveyed absolutely nothing at that point in time, and therefore that deed in and of itself would be void. To the court's point about the intent of the grant back in 1943, there is no evidence in the record as to what that intent was. The Heinz v. Allen case, which the lower court relied heavily on, as well as I think it'd be very instructive. It's a Texas Supreme Court case. It's from 1949, so it's not directly what the parties understood or believed in 1943. That case was on point because it talked about, in this case, it was a testatrix that devised her estate, her daughter getting the surface estate, and the heir to a trust to receive the mineral estate. And then the court went to say that the testatrix is presumed to have been familiar with the ordinary and natural meaning of words used of that will. And that case was also resounded through the conveyance of the deeds and penalized across the United States. And so it's to give that natural and ordinary meaning, not this hyper-technical, sensitive, scientific meaning, which is what essentially the appellants are trying to get at. The legislature, whether it was any didn't make any attempt to differentiate the types of sand. It just said sand in general. It didn't say high court sand, didn't say 85% court sand, 75% court sand. It didn't delineate anything. It said all sand in that. basically says, and it's 689 euro that was enacted, and it said essentially that unless you want sand to be included in that conveyance, you have to specifically state it. But when you use the word minerals generally, it will not be deemed to include sand. Again, it doesn't differentiate the different levels of that fact.
Counsel, let me ask you, suppose the plaintiff's case uh, 49 was also lost in 1949. It did allow for there to be, for sand to be considered a mineral, included in mineral rights in legal sense under some conditions. In Florida in 1953, we know what kind of sand would have crossed that threshold and been special enough or high quality enough to be considered a mineral.
Well, I don't think there's any record evidence at all as to what anybody understood or what was in place in 1943. So I think that is obviously something that we're going to pick up on, that we don't have any evidence as to what the party's intent was or what their understanding was as to what sand consisted of, whether it was valuable or not. I think the differentiation though in the Heinat's case and what they go through the state is exactly what you were asking earlier, is there is stuff when you're making glass out of it, and that's when you're actually drilling actual quartz, rock quartz, not necessarily this sand, which is a small particle size that's down to the millimeter. And so I think the differentiation on that is the value of that locatable mineral of quartz versus that sand part. I think the other part is there's no evidence in this case either that shows that this sand is used for anything other than road making and aggregate purposes. And so I think that that's another differentiation. There is no evidence that the sand on the Bronson Ranch is got some exceptional market value to be made for glass, to be made to do anything other than to be used for road making purposes from that part of it. And so I think that probably distinguishes that aspect as to the different types of sand in that regard.
Just to follow up, that if in 1943 that the sand from 3344 made the best concrete in the state of Florida, but it was concrete, could that be enough? Is just the fact that it's valuable or really valuable compared to other sand enough to make it mineral, or does it need to be something qualitatively different altogether?
First, that's right. Truly, if this sand on the Bronson Ranch was that valuable, certainly people would have been mining it back in 1943 and knocking down the doors out of the rest of the state of Florida to think this is the most valuable sand in the state of Florida. And that's not what happened at that point in time. The other aspect of your question is the fact that the value of sand is not derived, the value of sand in Florida, and what Mr. Hurst does a really good job of explaining, the value of sand is not the fact that it's sand or that quartz. The value of sand is because it's located, it's a locally sourced material. Meaning sand really has little to no value. Cost to mine the sand and to bring in the trucks to come in and transport that sand out is extravagant compared to the cost of that sand. And so the only time that sand becomes valuable is if you've got a local project where you need those trucks and that transportation to take that sand to in this case, a Polk County or a Lake County project that's locally accessible, so to speak. You're not taking trucks of sand from the beaches that also contain quartz sand, as Dr. Hetherington testified to. We're not going over to Sarasota County or to Manatee County loading trucks with crystal white sand that you see at the beach and lugging it all the way over here to Polk County and to Lake County. And that's because it has no value there because of those transportation costs. The value is the fact that it's locally sourced. And that's the crux of what Mr. Hurst went into in his testimony and his definition. Now, there's a couple of other things I think we have to get back to as well. There's been this notion that Mr. Bronson had converted mineral rights. The pleadings in this case are very specific. The allegations that he considered mineral, not mineral rights. What is undisputed is the fact that there was no mining whatsoever of mineral rights from the relevant time period in this case, and that was 2016 to 2020, the statute of limitations in that case. So There has been no sand mining or mining of any sort whatsoever. The case and allegations in this case were the simple conversion claim for minerals, and there was nothing to support that aspect of it. In addition to that, there was no evidence what other sand in Florida consists of. In fact, what Dr. Hetherington and Mr. Hirsch testified to is this type of sand and quartz sand is what the state of Florida is practically made of. That it came down here and you're going to find it everywhere from that point. Now, I'd also dispute this idea about this land, the sand mining lease and what it purports to be as the royalties and whether or not the court even wants to consider that. Obviously, Judge Durden didn't get into the sand mining lease. I'm not going to spend much time on that part of it, but it was a lease of that land. There's obviously mining, so there's really no value to that sand right now as it stands, or else people would be mining to that effect. And so it kind of contradicts this idea that this sand is so valuable, so to speak. I would note that Pine case that we talked about actually it was a limestone related case, but it did incorporate sand and gravel, but they actually did the testing of the limestone in that case, and they talked about that as well. And in that case, still, what they found is that limestone still completely destroys the surface. And in fact, with limestone, for every acre of limestone that was quarried, destroyed 5 acres of the surface is basically what they found in that case. And so it goes back to the whole point. And I think one of the things that I would point out as well is the PNN. I'll get the full citation too, because while I think that this is a new issue for this court and for the state of Florida, I think it also has to be considered that it complies with other existing Florida case law. And the PNN case that we cited, it's PNN Investment Corporation v. Florida Ranchettes, Inc., 27 PD 451. It's a first DCA case from 1968. But it talks about that idea of when the surface estate is severed from mineral estate, mineral estate is a dominion estate, and therefore that the owner of the mineral estate has a right of ingress and egress to explore, cannot so abuse the surface estate as unreasonably to injure or destroy its value, and is answerable in damages to that owner for any unreasonable injuries done. It goes to that same broad concept of what I kind of opened with. You still have to have this idea that any opinion, or what Judge Durden's opinion does, is it basically coincides and keeps that in mind too, and it's consistent with that law. That it does not allow the sand to be included in them too, because open terms of mineral rights, and because it would contradict with that case as well. I'm honestly wrapping up with what my presentation would be. I didn't want to regurgitate my answer brief. I stand behind it, and the cases that we cited, I could go through 20 cases across the United States that stand for the same thing, but I don't necessarily think that would be so I'll take any other questions that the court may have.
Thank you, Ms. Tucker.
Thank you.
Mr. Foster.
Yeah, getting to your definition of what the people consider back in 1953, I think you have to look at the case of Northern Pacific versus Soderbergh, which was decided in 1902. And it defined mineral lands. And it says, mineral lands include not merely metamorphous lands, but all such as are chiefly valuable for their deposits of a mineral character, which are useful in the arts or for purposes of manufacture. That's a definition of mineral lands back at the time in 1943. Watts confirmed that, and Watts says, which held that a reservation be considered to sever from the surface all mineral substances which can be taken from the soil and which have a separate value. And then also the case in the United States versus Isabel said that the reservation of minerals should be considered to sever from the surface all mineral substances which can be taken from the soil and have a separate value. So that's what was conveyed in 1943. And again, that would be what was actually taken this time when they took the corpse. It was a mineral with special value. It has special value. Just like two things. One is we did allege in our complaint, paragraph 5, which says more rights, mineral rights. It's in the complaint. Number 6, if you look at 765, 761, is a letter that says all of this talks about 300 and some odd 30 acres of what is considered concrete sand, which is a distinction. That's awesome. But clearly they're taking our mineral rights.
Thank you for your presentation. Appreciate it. Any